plaintiff's counsel.
Good morning, Your Honor. This is Jeff Molinar. With me is Andrew Haynes. We're from Osborne Maldon, representing the plaintiff.
Good morning, Your Honor. This is Robert Vaught with Greenberg Traurig, representing defendant Phoenix Children's Hospital.
All right. Welcome to you all. We're here for a hearing on the Rule 26D joint statement that you filed. And I've gone through the joint statement, and I want to just give you my thoughts on each item that is listed. So as far as the factual basis section of the disclosure statement, it's not a per se violation of Rule 26.1 that section tracks the language in the amended complaint. And I didn't see any specific objection or identification of something missing from the factual basis. So I'm struggling with what relief I can grant. And of course, it's difficult without actually seeing it. On the general objections to written discovery and the providing the 1,000-page range and the lack of a privilege log, I will tell you that generally, I think objections can't be general. They ought to be specific. There should be a specific Bates range and not just every document we've produced, and a privilege log to the extent documents have been withheld. But it sounded to me from the plaintiff's portion that they were going to be doing that. So I don't know if that's already been done in a supplemental response, but it sounded as though that was something that was forthcoming. So I don't know if that's something we still need to talk about, but my thought was what plaintiff suggested doing sounds reasonable to me. On the tax returns, I have now entered the stipulated confidentiality order, and the plaintiffs didn't seem to object to producing financial documents and tax returns. It seemed to me that the span of time, the time frame going back to 2015 was the objection. And I agree that that's an overly broad request. So to the extent the defense is still looking for tax returns back to 2015, that I need some understanding of why it's relevant, because my inclination would be to narrow it down to the time period that is relevant to damages in particular. And so, but I'll hear you out on that because I just, from what I've seen so far, I didn't see why we needed to go back to 2015. On counsel disqualification, that's just not an issue I can address in a Rule 26D hearing. I will tell you that generally disqualification is an extreme remedy that I don't take lightly. The law doesn't allow us to disqualify without a really good reason to disqualify. So, but again, I can't really make any determination on it without seeing full briefings. So on that issue, I will grant leave for you to file a motion and brief it fully, but it's just not something that I can really evaluate on such a thin record. So those are my thoughts on the issues, and hopefully I might have missed something, but I suspect that maybe there's been some updates since you filed your joint statement. So I'll hear you out on the issues or anything else you want to talk about today, but I thought it'd be helpful if you knew where I stood on everything. So I'll start with you, Mr. Molinar.
Thank you, Your Honor. We agree with you on, I think, all those points, and I think you covered the key issues in the joint statement. And I don't think there's really a lot of disagreement here, as you suggested, with the tax returns. We have those, we're compiling those, we're ready to produce them. I think there's 1 year for which we still need some information from the accountant. It really is just about the span. We propose producing from 2020 on. That goes even 2 years before the termination to the present, which would show what he was making at the time he was with PCH and then following. And we agree that 215 goes back way too far. It goes back years before he was even employed by PCH. So we would propose to PCH and Mr. Vaught that we started 2020 and tax returns from 2020 to the present would be produced.
Okay, on that issue, I don't know who's arguing for PCH today.
That's me, Your Honor, Mr. Vaught.
Mr. Vaught, what are your thoughts on narrowing down that request to 2020 forward and instead of going back to 2015?
Your Honor, we did request from 2015 onward, and we did that because, and this kind of relates to some of the other issues that we've raised regarding what's been disclosed more than 2 years into this litigation. We asked for that far back to get some before and after comparison data. Part of the issue here is that what we've received from plaintiff to support the one remaining claim that they have against my client, which is this tortious interference claim, we're missing basic pieces of information about what my client allegedly did, how my client allegedly interfered with studies that Dr. Frye worked on during his employment, after his employment, how we allegedly or my client allegedly interfered with people. We don't have basic pieces of information that should have been disclosed under Rule 26 and weren't, should have been disclosed in response to discovery requests and weren't. So the reason we went back to a couple of years before he began is because we still don't know exactly what Dr. Frye is alleging in terms of what PCH did. Now, if the court, orders a reduction in the span, we're happy to get any information to support the damages claim that has been made here. But that's the reason why we went back so far, is because we need some before and after comparison to see what, if at all, damage that Dr. Frye has suffered here.
Well, I guess my question is, what are the tax returns relevant to other than damage?
They're relevant to damages. I mean, that's a significant component of, again, the one remaining claim is that Dr. Frye is alleging anyway he has suffered substantial economic harm. If that's true, those would be reflected in his tax returns. We'd be happy, Your Honor, certainly on the disqual issue or any of these others to provide briefing with the law or any other facts, but it's damages. That's the issue, Your Honor.
Okay. Here's my thought on it, is damages are a reason to require production of financial documents in a case like this, where they are tied to a loss of income. But I have to be careful, both in terms of proportionality and relevance, in letting you dig too far into someone's financial records without a firm basis for it. And so what I really need to see is, number one, a disclosure of the calculation of damages, and then something where you can show me, we need to go back further than 2020 or further than 2017, because here's their disclosure and we need to compare it to these particular things. And so what I will say is, I will order Mr. Molnar, and I don't know if you've gotten that far with your calculation of damages and the time frame in particular that damages are being sought. Can you tell me that, Mr. Molnar? Because that's really what I'm looking to, is tying it to the time frame.
Well, I think with respect, Your Honor, to lost income, that's why we think that even goes back further than necessary to go to 2020. There are other things that will help define damages too, both fact discovery and expert discovery. And if I may, Your Honor, I just want to put the time frame here in context. Mr. Vaught talked about this being going on for 2 years. The parties exchanged initial disclosures in March. So we're talking about 5 months worth of discovery. And one thing too, when it pertains to damages and just the substantive claims, this is a two-way street here. We certainly reject this idea that we have been providing relevant information, but some of the things that go to both damages and the basis of our claims are all within PCH's possession and things that have not been produced. For example, communications with the people involved in those studies, internal communications about the decisions that were being made. We haven't received any of that. Part of damages and the underlying claims are what communications PCH had internally and with others that we haven't received yet. So I'm confident that ultimately PCH will produce those things. Unfortunately, we likely have another 26D coming down the road because of the lack of production, but I just wanted to address that because I think that was a mischaracterization of where we are collectively in discovery and with what we've done.
Here is what I will do, is I want you to, I'll set a deadline for the production of the tax returns going back to 2020. I will make my ruling without prejudice to the defendant filing a motion requesting additional years of tax returns once you have more discovery done and you can tell me more specifically why you need to go back that far so that it doesn't feel so much like a fishing expedition, but you can give me a concrete reason why I should allow additional discovery on those. So you'll still have that opening if you need to come back to me, but I just need more information to justify it than I have right now. How soon can you get the tax returns over to Mr. Vaught?
I would expect, I don't think there'd be a problem getting it to him by the end of next week. And only reason I hesitate is because I think there's some from 2022 that we're trying to get from the accountant. So I would say by August 14th, it shouldn't be a problem doing that, Your Honor.
All right. Any problem with that, Mr. Vaught?
Your Honor, again, our position is these should have been disclosed a long time ago. We're getting ready to depose Dr. Frye. I'd like to have them as soon as possible. And my only reference to, he filed this lawsuit 2 years ago as if he has been damaged as he claimed he was damaged 2 years ago. These should have been at the ready. I'd like them sooner, but I'll take them whenever we can get them.
Do you have his deposition set? When is it set?
We had noticed it. I think that we just got word that the date that we had noticed is not available. We'd like them within a week, if that's possible.
Well, it's Thursday, so they're really asking for a week and a day.
A week and a day would be good, Your Honor. Thank you.
Okay. All right. So it is ordered that plaintiff shall produce tax returns dating back to the tax year for 2020 on or before August 14th, 2026. That ruling is without prejudice to defendants seeking additional tax records for additional tax years upon a showing of good cause, and defendants are granted leave to file a motion in the event further information becomes available justifying a broader request for financial documents. As far as the supplemental responses to written discovery, Mr. Mulliner, your portion of the statement sort of suggested that you were already going to do that or would do that. Have you already produced supplemental responses? Can you tell me what the status is?
Sure, Your Honor. No, we have not produced those yet or disclosed those. We did promise to do that before the discovery statement was filed, and we still intend to do that. And we will do that, Your Honor. And hopefully that will resolve that part of the dispute.
Okay, and so what I will do is just order that supplemental responses to written discovery be provided by plaintiff that shall include specific rather than general objections to any discovery request, and shall identify specific Bates ranges of documents already produced that are responsive to each request, and a privilege log to the extent documents are withheld. And if you can get those over to Mr. Vaught by the 14th as well, that's the deadline I'll set so that you have them in advance of the deposition. As far as the search for communications, that was something that was alluded to in the joint statement, but it wasn't really made an issue in the joint statement. But when I was looking at it, my thought was communications in this day and age are really a function of searching for ESI. And I don't know that I didn't go back to look and see if you have an ESI order that you've agreed to, but to me, that's really what you need to do is sit down and talk about a protocol for search terms, how you're going to search, and that probably ought to go both ways. And then if you can't agree upon a protocol, you can bring that back to me in a 26D or a proposed order from each of you. But first you need to have that conversation of here's where data or how communications occurred and where it's stored, and how can we narrow this down so we don't end up with a terabyte of responsive information. And so that was my thought on the communication issues. I'd really like for you to sit down and try and agree upon searches and a protocol, and then if you have an issue, at least by that point it'll be more narrow, and I can help you work through any disputes you have after the fact.
And Your Honor, we have been doing that, so the court knows. I think we've agreed on a list of custodians and a date range, and I think we're near agreement on terms. So just so the court knows, counsel have been engaged in those discussions and hope to have that process underway soon.
Okay,
At least
good.
with respect to PCH. I agree that it's a two-way street, and we'll be requesting Dr. Frye to do similar searches.
Okay, so we'll table that and know that you can bring it back to me. I don't want to discourage you from bringing genuine disputes to me when you need to. When it comes to those, a lot of it depends on where data is stored, how it can be searched for, and you and your clients are going to be better served by conferring on those issues before I get involved. Are there any other issues we can or should talk about today while we are on the line?
Not from plaintiff's side, Your Honor. Thank you.
No, Your Honor, we appreciate the order on supplementation. I will just say, and I look forward to receiving the supplemental responses, because again, a frustration from my client's perspective at this point, based on the claim, is that when plaintiff makes the allegation that somebody from PCH said something to someone that interfered with a relationship I had with that person, and we ask who from PCH said it, what was said, and to whom was it said, and the response is nothing, crickets. That's the kind of frustrating position we are in at this point. I look forward to the supplement. I appreciate that the court ordered supplemental production, but that's the kind of basic information that we don't have despite the request. So we appreciate the court's order. We look forward to receiving the supplement, and hopefully we'll get the information that we've been asking for.
Well, and here's what I'll say on that issue is that really there's no upside to the plaintiff not disclosing evidence that will support a claim, because at the end of the day, if the evidence isn't disclosed, then it's not going to be there to utilize in support of their case. So if, to the extent there are details that need to be disclosed, it benefits everybody to get those out there. And that's why disclosure and discovery rules operate the way they do. But at the same time, I can't force someone to disclose something if they're telling me it doesn't exist. So, when I have someone telling me I've disclosed everything I have and the other party saying, but there has to be more, there's really not a remedy I can order until I have proof that there actually is something more that a party knows about, has, and hasn't disclosed. So again, confer if you need to bring something back to me specifically. And I will tell you just going forward that if you need to file Rule 26D that involves written discovery, I know the rule says you can't attach anything, but I prefer that you do. Just give me, if it's a 30B6 deposition, attach the topics. I'm not going to ding you for that. And it just makes it easier for me to actually see what it is that, and for example, if you have a response to an interrogatory, give me the response, the objections, and the question, because I'm okay with you attaching it no matter what Rule 26D says. Now, I don't want you to give me 26D statements that are 100 pages long, but so use your discretion in that regard. But if we have future conferences where it involves something I need to look at, like a written discovery request and objection, it's okay to attach it so I can see what you're talking about. Okay.
Thank you, Your Honor.
Yes, Your Honor.
All right. Thank you. Have a nice day. We're off the record.
Thank you, you too.
Thank you. Bye-bye.